Hi, my name is Isaac Shutt. I'm an estate planning and probate attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, I'll answer a question that comes across my desk from time to time, and that is, how do I cut out a beneficiary or cut out an heir? Maybe the situation is where you've got a child that's estranged from you and you don't want to leave them any part of your estate. How's the best way to do that? Well, it's a great question, and it's something that you should be really, really thoughtful about, because what happens is if you have a natural heir, like a spouse or a child or somebody like that, who in the absence of a will would be entitled to inherit something from you, you need to be careful in how you deal with those people, because it's actually super easy for them to get an attorney after you pass away and create a ruckus in the probate courtroom for your surviving family. And a lot of times these people who would be entitled to a share in the absence of a will, they have an incentive to contest the estate, your will and so forth, because they have no reason not to. I mean, if they lose, they get nothing. And if they win, they get a big share. And at least maybe they can run up the cost against everyone else who is inheriting so much that people just roll over and give them a little something. And in fact, that's normally what happens. If we don't have a really good estate plan, that person who's been cut out gets some attorney to dispute things and file in court, because why not? And then usually what ends up happening is the people who are inheriting end up just paying them something to go away. And I really hate to hear that for the people who are supposed to be inheriting, because it's kind of like extortion. Totally legal, but it doesn't feel right. So there are some really practical things that you can do if you're wanting to cut somebody out altogether to make sure that the likelihood of a contest in court are much, much lower. So the first thing I would say as a good practical piece of advice is go see a lawyer. If you're cutting out somebody who would otherwise inherit, you have to be careful. The T's must be crossed. The I's must be dotted. It is so much more important that everything be done correctly. And so I've got another video about how to be careful about having a no contest clause and making sure you see an attorney to make sure that there isn't a beneficiary dispute. You might want to check out that video as well. But suffice it to say, for this video, it is so important, if you're cutting somebody out, to go see an attorney who knows what he or she is doing, who's been in the trenches, who's litigated these things before, and knows how to make your stuff hold up in court. There are lots of tips and tricks and things that we learn along the way, and a good experienced attorney knows those tips and tricks. So let's say that somebody comes into my law office and says, Isaac, I've just lost this relative. It was my dad who died. And I don't think my dad had a will. I think my dad actually had a trust. And I say, okay, well, how can I help you? And they say, well, I think I've been cut out, but I want to challenge that trust. And I'm like, okay, good. I handle cases like that. I'd love to help you, but I have to have a legal theory. I have to have a factual basis for contesting that trust. So, what's your factual basis, dear prospective client? Why am I attacking this trust? And I don't really know. With a trust contest, I have to have a good factual basis. So are you telling me that the trust document was forged? And usually the answer is, well, I don't know if it was forged or not. I haven't even seen the document. Okay, well, can I challenge this trust because your dad might have lacked mental capacity when it was signed? Well, I don't really know, because I don't know when it was signed exactly. Well, are you telling me maybe he was pressured? Did somebody unduly influence your father into signing that trust? Well, I couldn't really be sure. I mean, I haven't seen the document. I mean, it seems like it's possible. And I'm going, well, geez, client, I would love to represent you in contesting this trust, but you haven't even seen the document. You don't know anything. You have no factual basis for contesting the trust, and so I am not going to file a frivolous lawsuit on your behalf. I do not like you that much. I don't want to get fined by a judge for a frivolous lawsuit because you haven't given me any factual basis for contesting that trust. So the important thing to keep in mind of why the trust is better if you're cutting somebody out is that the trust document itself is not public record. However, the last will and testament is public record when you die. So when you pass away, that last will and testament, when it goes to probate court, and every will goes to probate court to be probated, your will becomes public record. And that, now that I can see the will, and I can see the date it was signed, and I can see, how swoopy your L was in your signature, and I can see all of that stuff, that gives an attorney something to sink his teeth into to contest the will. On the other hand, since the trust is literally off the record, you have not given anything for an attorney to sink his teeth into to dispute the document, because we don't know when it was signed or if it might have been forged or whatever, because you haven't even seen the document. So for that reason, and it's an important reason, if you are going to cut somebody out, seriously consider not only getting an attorney, but asking that attorney about whether or not a trust could be right for you for those privacy reasons to minimize the likelihood of a contest. I hope you found this video helpful. Again, my name's Isaac Shutt. I'm an estate planning attorney and probate attorney. I'm licensed to practice law both in Texas and in Wyoming.